Okay. Okay. So we saw an interesting machlokas. Oh, whoops! Oh, I forgot to put the dongle. We saw an interesting machlokas yesterday between the Maharsham and the Nesivos, two 19th century poskim. The question really is, what is the reason why, when a person goes to secular court and then wishes to move it to a beis din, that we don't give him that option? So we saw two reasons. Number one is that once you've committed yourself to abide by the ruling of the secular court, you've sort of forfeited financially. You've basically a financial forfeit of whatever a beis din would rule on your behalf. And the second reason is because of a knas, is because we view it as a penalty. We penalize a person for having committed the aveira, whether it's d'oraisa or d'rabbanan, of going to secular court. And that's the reason why we don't allow him to go to beis din afterwards. So he says that one of the nafkaminas is going to be, what is the status of a person who is nitva? He is taken to court. He's the defendant. The plaintiff takes him to a beis din. Does he have and let's say he loses, does he have a right to take the guy to beis din? So on the one hand, he's committed himself, but on the other hand, we said that maybe he's not to blame because he didn't start the proceeding in secular court. But then the question is, well, then why didn't he protest? It could be he didn't know that he could protest. And so that was the back and forth. He says that we also saw that in the event that the nitva, that the defendant prevails and ends up winning more than he would have gotten in a beis din, so there's a machlokas as to whether he's allowed to accept all of that award or not. The Maharsham says he would, and the Nesiva says no, he really shouldn't. So he says, and so the concluding paragraph of this whole discussion is, Amura min ha'amur sheyesh shtei nafgaminas bein machlokas haNesivos v'Maharsham hanal. It turns out that there's two sort of areas of dispute between the Nesivos and the Maharsham. He says, first of all, a defendant who is taken to secular court loses the case and then realizes that he wants to go to beis din. That according to the Nesivos, because he did not start the action, we do listen to him, and the beis din will send the hazmana to the other party. And according to the Maharsham, because the guy didn't say anything and just went willingly along to the secular court, we also don't attend to his request. V'chein lahefech, be'echad shetava acher she'eno tzayis ledina le'erkos beheter kedei lahatzil mamona. Or in an opposite case, where the defendant refuses to go to beis din, and so the plaintiff has to sue him in secular court, the harkos chivu et hanitva yoser mikavidin din Torah, and the nitva, the guy who was the one who refused to go to beis din, ends up losing the case, but ends up losing more than he would have lost in a beis din. According to the Nesivos, you're only allowed to take what you would have been awarded in a beis din. Well, so in other words, you have to you have to leave the penalties on the table. If, let's say, the court assigns punitive fees and things like that. And according to the Maharsham, you'll be permitted to take everything, because once the guy submits himself to secular court, he's basically thrown the dice and is willing to lose everything. Okay.
is between, does it go to the doctor or something? Does it stay with the court? Or does it go to, does
No.
the person pay less?
No, you would basically tell the guy, I know the court told you to pay me $1 million,
Pays less.
but in Basin, I'd only get $500,000. So give me $500,000.
Okay.
That's what you'd have to tell him.
It's between the-
I've never heard of anyone going according to that ruling. Never heard of it. It doesn't happen. Well, you would ask a shaila. In other words, let's say it's clear that the secular court has tacked on additional punitive fees, right? Penalties that would never have been present. It's clear and present, like it's obvious, right? Okay. Okay. Siman Zayin, next shaila. Bedin Tiviat Chevret Bituach Be'erkos. Taking an insurance company to court. Can you take an insurance company to secular court? Okay, and here's the sheila. Adam shenechval b'tu'onat derachim. Guy is injured in an automobile accident. Ha'im muter lo lifnot le'erkot litvo et ha'bituach shel hamazik k'dei lekabel mehem kesef. Can I now start a court action in secular court, not against the driver, but against the driver's insurance company, so that they'll pay out. Afilu sheyakabel yoter kesef mima shemagil lo al pi din Torah, even if it means that I'm going to be awarded more than perhaps what a beis din might award. B'chein rofei shegoram nezek l'choila, or a similar question: a physician causes injury to a patient. Can a patient sue the doctor's insurance company? In other words, ultimately, when I sue the physician, I'm suing the insurance company in order to be able to collect, even though the insurance company, under secular law, might be paying out more than what a person would get if they went to a din Torah, right? So right, because every doctor has malpractice insurance, right? Right. So if I might phrase the question a little bit differently, can I sue my from doctor knowing that I'm really just suing the insurance company? I'm not suing the doctor.
This point that the doctor's Jewish, and normally if you sue the doctor, you'd sue him, go to beis din. But since it's not the doctor,
right?
It's
like if I had a financial dispute with Warren that had nothing to do with his medical practice, I'd have to take him to beis din. All of a sudden, it comes to medical malpractice. Well, Warren has insurance for it. So maybe that changes the whole situation, because I'm really collecting money not from Warren directly. I'm collecting it from his insurance policy. So maybe that changes.
If I lose, they pay. So, not that you sue the insurance company, you are suing me. It's just that I have protection, just like anybody would have protection against a major lawsuit with common practice in commerce, and even accountants and lawyers have a kind of protection. So you are suing the individual, but maybe
The individual doesn't have to pay. Is the paying or the suing? What is the problem?
Well, the problem is normally when two Jews have a dispute, they have to go to beis din.
Insurance company is ultimately the money's not, so that's why I'm asking, is it the money? If the insurance company pays the money, you know the doctor or lawyer is doing this. Who's paying the money?
Well, the insurance company is ultimately going to be paying.
So in the end, I suppose you could say
That's what I'm saying.
Well, this is the basis for the Shiloh, right?
on what they paid out. Every insurance policy is a right of subrogation, so.
Even though you've been paying your premiums?
No, yeah, it's a car accident. that you sue. Then tort fees or whatever, the person who caused the problem, the insured. And then the insurance company can then say, well, we paid out in your behalf, we're gonna seek some kind of indemnity or whatever. There is that possibility that something can come back to him as well.
It sort of gets
But it's
reflected in
not
your,
from the Tovea, it's from.
It's from the insurance company.
it's gonna get reflected in your premiums for sure.
That's-
Right,
that's-
that's
It does
increase in
impact-
premiums. How does that
Money does
affect?
impact on the
Yeah.
insured sometimes.
Yeah. I've never heard that term subrogation.
Subrogation.
And doesn't that sort of defeat the whole purpose of paying for
You
insurance?
know what, maybe the apply, subrogation usually is they step into the shoes of the insured. And then maybe when there's a third party, right, when there's a
Yeah.
third party, they
Yeah.
can sue the third party for the amount they paid out for their insured to get to recoup their money. No, it's not again.
It doesn't come back to the insured. It doesn't come back to the insured.
Insured,
Right.
right, and they paid out on the insured's behalf,
Right.
they can then step into the shoes of the insured and would try to recover the money they paid out for their, on behalf of their insured.
Uh-huh.
So so it's not the insurance, third party.
Right, but the insured is
Go after
impacted
the
by,
third party, somebody, they step into the shoes of, they were to lost it.
it's an increased premiums for sure.
But there's increased.
Do they deal with, the doctor that gets sued for the car accident?
Typically, they don't. Typically are based in, I've never heard of it. That doesn't mean, like, again, I'm not an expert on a bate din, but typically a based in will not hear a case like this. And the question is, why not? Right? And that's really what we want to try and understand is like, we want to try and understand that, like as Warren said, it's not so clear cut. I'm really suing Warren. I'm not suing his insurance. His insurance will pay for him if he loses the court case. And there is damage to his reputation. But,
Just so
right.
Everyone knows, this says after found guilty in a certain medical malpractice case, that becomes public knowledge. So, assuming I'm the person who lost the case, and I'm still allowed to practice, assuming it doesn't affect my ability to practice, anyone who goes on the College of Physicians and Surgeons website will have public information, maybe not the gory detail, but the fact is that it's public knowledge that I lost the case.
How often in medical malpractice does it go to actual court? Don't they usually settle these things?
It depends what it is.
90%.
Yeah.
Most are settled because
That's what you are, this is the first, and if they win, then they can take it to a civil level.
and that's.
I'm sorry, I didn't follow.
So, everything's done in this malpractice that we have. You get a lawyer, they get a lawyer, they take it and college basically flushes the whole case out. And if you end up, you having been, malpractice, guilty malpractice, then after that, the patient could take you to court. Those when you see on the paper, on the front page of the
Uh-huh.
That's right. So
And
and-
they try to
so
settle it first. but
they settle it,
sue
but
all the
even
time.
if it gets
Never
settled,
goes outside.
depending on what's actually happened, reason being sued, it can end up still going to civil court, and I think that's even a more interesting question. What happens after it's, now I'm still going to sue you in civil court, now I'm supposed to go to the.
is the first round criminal charges or?
Well, it depends, is it medical malpractice or is there something else that doesn't fall under the
Right.
umbrella?
And
of
that's why they have a
medical
civil
malpractice?
recourse as well following.
Yeah, exactly.
Getting a real education today.
They are on a settlement, mostly they don't, or they go to court and get a judgment against the doctor and in trial, and then the insurance company will pay out the judgment. What's going on?
So in the way it works in Canada is that you go through this system of the physician's college. They do their own investigation and evidence gathering, and they will make a decision. It's like it's not even part of the Ontario court system, and they'll make a decision whether there was malpractice or there wasn't. And based on that, the insurance company will have to pay based on the ruling of the college. Is that the way it works here?
Lawyers not involved. Doctors, lawyers involved. Plaintiffs, lawyers the other side, they're the patient. Goes to
Who's the judge?
the judge, college.
The college is.
The college.
This is outside the court
Which is,
system.
that's why it's outside.
Yeah, it's extrajudicial.
Right.
Right, that's why they have a right subsequently.
Unless they actually win.
Right, because that would be the foundation.
Well, if they win in the college case, why would they then go to secular court? Is it? Yeah,
Because maybe the settlement wasn't.
Money,
They're
they need quantum.
not happy with the
Or
settlement.
they wanted to fame, or they wanted to take it to the next level. That was a lot of emotion.
Yeah.
Or there's an element that is not purely malpractice.
Meaning, like what is it about real
Doctors do strange things.
It's a discipline. See, not only were you negligent, but also. Something.
Well, then wouldn't it go to a criminal situation?
But they can make more money on a civil basis.
You can try to sell. But you don't have to. Straight to money. Super negligence. Law firms specialize in that.
Okay, well, this is
Another
very
angle
helpful.
about all this, what happens in marriage as well, where the insurance companies are Jewish?
Yeah, right. So we'll have to see, you're absolutely right, Paul. We'll have to see, does that change things? Because the insurance company is, let's say, a Jewish-owned insurance company, or do we say that because it's a corporate entity, it doesn't have the same status as a fellow Jew?
All of this practice in insurance. Sue a Jewish, in Israel, a Jewish supermarket or something like that.
Yeah.
Just looking forward. Is it a corporation? Doesn't have to go. to
I guess it
Israel?
depends on whether it's a privately owned makol, whether it's like a corporate, what is it, Super Sol or Usher Ad, or
Yes.
yeah. Well, let's see. Okay, so the tshuva is as follows: Mutar litva be'erkaot demei pitzuyim hamishtalmim al yedei chevrat bituach al ta'ona. It is permitted to go to secular court to pay for damages that would be paid out through an insurance company as a result of an accident. He says, even though the insurance company might in all likelihood pay out an amount that is higher than what a person would be entitled had they gone to Beis Din, you're still allowed to accept it from the insurance company when the courts rule against the insurance company, because that was the whole reason why the guy had an insurance policy in the first place. He was paying a monthly fee. He says, and this was a business arrangement between the defendant and the insurance company. The insurance company basically agreed that if you get sued in secular court, we pay for you whatever the secular court tells us to pay. So the insurance company is basically committing themselves to pay on behalf of a private citizen. And this has the power even according to the Torah. Like basically, it's no different than if I act as your guarantor to pay a debt that is decided upon. And I say, whenever Plony tells me to pay you, I will pay. And you and I make a kinyan, like, right? So Reuven and Shimon make a kinyan, and Shimon accepts upon himself that whatever Levi tells me to pay you, I will pay you, right? Or if you end up if you end up harming someone, and Levi tells me that I have to pay that amount, then that's the amount that I will pay. In other words, I am accepting upon myself from the outset to be governed by by the whim of an individual or an entity that is outside of the Beis-Din system. That's what the insurance company is agreeing to do. And even though you're not allowed to take a fellow yid to a secular court, as we've been discussing now, but since we know that the insurance company is not going to accept the summons to a din Torah, and there's no other opportunity to stake a claim against them, so you can sue them in the secular court. Now, he keeps saying you can sue them in the secular court, meaning the insurance company. But the fact is that, as Warren has argued, I'm really not suing them. I'm suing the driver, or I'm suing the doctor. It's really there. The question really is there any difference? But let's take a look. First of all, he says that this was the psak of Reb Sternbuch and Reb Zalman Nehemiah Goldberg, and he doesn't go into any greater detail. And he says that this whole din, as far as having to go with the secular court, is based on what appears directly in the Shulchan Aruch. He says, "Hayta yad ovdei kochavim takif." The Shulchan Aruch writes that in the event that the secular government is in control, and you need to sue someone, and you don't have the ability to sue him in a Beis Din, because the Beis Din doesn't have the power in this particular situation to coerce someone to go to Beis Din. Yitva'enu l'dayana Yisrael tchila v'im lo ratza lavo notel rishus mi Beis Din umatzil b'dayana ovei kochavim miyad baldino akam l'shona. So, as we learned in the last tshuva, if someone is not going to go to Beis Din, you have to formally send them a summons, and if they refuse the summons, you receive permission from the Beis Din to take them to secular court. V'lachein hachanami, keven shelo yachol litva mehachevret bituach bebeis din, yesh lo heter lifnot le'erkaot. And similarly, in our situation as well, since an insurance company is never going to accept the summons to go to Beis Din, you therefore have although, if they found out that Beis Din would award the damaged party less money, maybe they'd be maybe they would be inclined. What are the big insurance companies here in Canada? Manulife, right? Yeah, maybe Manulife, if they found out, they would say, "Hey, we'll go to Beis Din." Now, the Afal Shebishulchan Aruch Kosav Shekodem Tzarich L'Tova B'Dayoni Yisrael, even though the Shulchan Aruch does say that you first have to send a summons from the Beis Din, and only if they refuse to acknowledge the summons, and then you have to, then you get permission from the Beis Din formally. Mikol makom kosav bekesef hakadoshim ala Shulchan Aruch sham dim yesh umdeda demuchach shahanit v'lotzayis dina. But if it's clear, in other words, there's a clear and present indication that the defendant will refuse to go to Beis Din, yochol l'tovel miyad be'erkos v'lo tzarich rishus Beis Din ayin sham. Then you can immediately go to Erkos, and which is a big chiddush, by the way. right? In other words, Manulife is never going to acquiesce to the summons. So therefore, you don't even have to go through the formal process of sending a summons. V'chein pasak Rabbeinu, not sure what this abbreviation is. Halacha l'maisa b'shut v'hayahu lam legabe rav meforsam she'iton chiloni hotzi alav shemra. There was a case about a famous rabbi who was slandered by a secular newspaper in Israel. Okay, v'ratza harav hanal l'tovim be'erkos kevin shepashu baruch shelo yavu l'din Torah. And he wanted to sue them in secular court because he knew that if he summoned them to Beis Din, they would just throw it out the piece of paper and laugh at it. V'Rabbeinu sham helo lahatir hadavar al pi ma shekasav hakesef hakadoshim hanalayin sham. And this Rav, I don't know, he's Rabbeinu Hagon Hamaforsam, maybe. I don't know who he's referring to. I'll have to figure that out. So a contemporary Gadol paskined that based on this understanding, that if you know in advance that the defendant is never going to go to Beis Din, you don't even have to go through the formal process of sending them a hazmana. Okay, and therefore you can say the same argument with an insurance company. V'chein pirish b'shut avnei yashvei, u'b'shut shuvos v'hanhagos, u'b'shut yashiv Yitzchak, v'chein sideid hagrish el Yashiv zatzal. And Rebbe Yashiv felt pretty much the same way as well. Okay, now the problem is going to become, what if the plaintiff is from, the doctor is from, and the plaintiff says, I want to take you to Beis Din. And the doctor says, how can you take me to Beis Din? My insurance company is never going to go for that. They're never going to allow me to do binding arbitration outside of the college. There's just no way I can do that, right? Would that ever be a thing? It's not even possible, right? Yeah, it has to go through the system. Yeah. Okay. It is what it is. Right. Now, what if an insurance company, however, would you think an insurance company might agree to binding arbitration?
Also, it's a bit of a form and substance thing. Courts won't accept your claim against the insurance company winning the lawsuit because you don't have a cause of action against the insurance company. You have a cause of action, let's say, against your guy, right? So you have to name your guy. But what in reality happens is once you name Plony or whatever, the name, he runs off to his insurance company, whatever, malpractice or, property damage or whatever, personal injury or something. And the insurance company under the policy is responsible, like Warren said, to appoint a lawyer and pay for it. And the lawyer then behind the scenes represents the insurer, right? The insurance company. But it's never named in your lawsuit because you don't have a right to sue them.
Right. Right. So you're really not, there's never any, but it's never explicit that you're suing the insurance
company. It's always
company.
behind the scenes. So when you come to, let's say, mediation or arbitration or whatever it is, there's always a lawyer there, but they're not being paid by the guy, right? They're being paid by the insurer behind the scenes, sending bills to them. Nobody knows it.
Get a fee, yeah, that's not insurance.
No.
But no matter how expensive the lawyers are, doesn't matter. It's no different to a car accident or whatever.
Yeah.
And then it's spread out. So every year you just see those adjustments in there. Premiums, whatever they are, your house, your car, your medical insurance.
The only time you'll see, say, the plaintiff in this case would sue his own insurance company in court when they refuse to defend or appoint a lawyer or anything like that. And he's saying, now you breached my policy. You're not giving me what I paid for with my premiums. I'm suing you to compel you to defend me and, and all of that. That does happen. But you never see the plaintiff suing the defendant's insurance company straight up. It's always them, and then they always run off to get the insurer.
Okay. And he says, "V'hu hadin l'rofe shegoram nezek l'chola b'rash lanuto." And the same thing, therefore, would be true, not just with an automobile accident and suing the insurance company, but also if a doctor causes illness to a patient through malpractice, shirashai hachole lekabil pitzuyim midemei habituach, and therefore the patient is allowed to accept compensation from the insurance company in the same way. Yeah.
I'm the doctor, and we together own a medical clinic. So the argument is not about my medical practice, it's about perhaps some business practice that you as the business partner are concerned about, not medical practice, business practice.
Yeah. So
That will go to, and that is not.
there's no insurance involved in that.
No, so that's me and you. Based in.
Yeah. Yeah.
So that's where it's important for people to understand. It's not anything specifically.
Right. Where there's an insurance company involved.
Or where the patient is opposed to any other infringement
Yeah.
that the doctor. So I think.
Yeah. If it's purely a business association, right? Okay. We'll hold it here. There's one more paragraph we're going to read in this tshuva. We'll get to